If the promise of justice begins with truth, then the fulfillment of that promise demands transparency and accountability. In every corner of the criminal legal system, especially within law enforcement, transparency is the foundation that enables oversight, and accountability is the mechanism that enforces standards. Without both, the system collapses under the weight of unchecked power, hidden misconduct, and eroded public trust. This chapter explores the reforms necessary to improve transparency and accountability within policing, focusing specifically on how those reforms can bolster the duty of candor. Drawing from model policies, legislative trends, civil society proposals, and lessons from high-profile failures, we identify the tools and principles that can bring meaningful change. The aim is not merely to deter dishonesty, but to normalize truth-telling as the professional standard, one that is backed not just by values, but by enforceable systems. Transparency and accountability are not mutually exclusive. They are mutually reinforcing. Transparency exposes problems. Accountability addresses them. Together, they ensure that the obligation of complete candor is not aspirational but structural, embedded in every level of law enforcement practice and culture. Redefining transparency in law enforcement. Transparency as a public right. Transparency is the public's window into the conduct of government, particularly those who wield the authority to detain, arrest, search, and use force. In the context of policing, transparency allows communities to see how officers are trained, disciplined, and held to ethical standards. It enables journalists, advocates, and oversight bodies to monitor the behavior of public servants paid by and empowered on behalf of the people. Transparency is not an act of generosity from the government. It is a constitutional imperative and a democratic necessity. When government power is obscured, the opportunity for abuse increases exponentially. In the words of Justice Louis Brandeis, sunlight is said to be the best of disinfectants. Categories of transparency. Effective law enforcement transparency encompasses multiple domains. Officer conduct records, including disciplinary actions, sustained misconduct investigations, and use of force incidents. Brady/Giglio material. Lists and disclosures identifying officers with known credibility issues. Internal affairs outcomes, findings from complaints, investigations, and supervisory reviews. Training and policies, materials that outline expectations and procedures for ethical behavior. Body-worn camera footage, visual records that can confirm or contradict official narratives. Public complaints and citizen review outcomes. Data and summaries of community-reported misconduct. Each of these categories represents a potential tool for oversight and a necessary component of truth-centered reform. Making Brady and Giglio transparent. One of the most critical yet underutilized forms of transparency is the disclosure of Brady and Giglio material. While the legal obligation to disclose such material is well established, public access to that information remains rare and often contested. Creating public-facing Brady lists. Some jurisdictions have taken steps to publish partial or redacted versions of Brady/Giglio lists, making it easier for the public and the defense bar to understand who is testifying in court and whether their credibility is in question. These efforts promote fairness, reduce prosecutorial discretion abuse, and send a clear message that integrity matters. Key features of effective public-facing Brady systems include clear inclusion criteria, e.g., sustained findings, pending charges, judicial findings of dishonesty, regular updates and review cycles, notification procedures for listed officers, and the ability to appeal, public summaries of misconduct, not merely names without context. While critics argue that publishing these lists damages reputations or invites lawsuits, the constitutional rights of the accused and the public's interest in reliable justice must take precedence. Institutionalizing the disclosure process. Transparency in this area also means internal consistency. Prosecutors must adopt formal policies that mandate routine review of officer conduct records, trigger disclosures without delay, and ensure that all relevant material reaches the defense in a usable format. Law enforcement agencies must reciprocate with real-time notifications of any misconduct that may affect courtroom credibility. Technology can help. Case management software should include flags for Brady/Giglio issues, and officer disciplinary histories should be integrated into prosecutorial databases in a secure but accessible way. Public access to disciplinary records. The problem of secrecy. In many states, police disciplinary records are shielded from public scrutiny by state law, union contracts, or local policies. This legal opacity enables agencies to conceal repeat offenders, obscure patterns of abuse, and resist accountability. Until recently, even civil litigation discovery processes could not pierce these shields. Reporters were stonewalled, prosecutors operated blindly, and defendants were denied key impeachment material. The result? Officers with known histories of dishonesty continued to testify. Individuals were convicted based on tainted testimony. Public trust eroded. Legislative reform efforts. In the wake of high-profile police misconduct scandals, several states have begun dismantling these secrecy barriers. California's SB 1421/2019 made available previously confidential records related to officer shootings, use of force, and sustained findings of dishonesty or sexual assault. New York's repeal of Section 50A 2020 removed one of the strongest confidentiality laws shielding police personnel records in the country. Colorado and Massachusetts have passed transparency statutes linking officer misconduct to decertification databases and public reporting. These reforms have enabled journalists, watchdog groups, and defense attorneys to obtain records that were once impossible to access. They also serve as models for other states still operating in secrecy. Independent oversight mechanisms. Transparency without accountability is observation without consequence. That's why civilian and independent oversight is essential to building a culture of candor in policing. Civilian Review Boards, CRBs. Civilian Review Boards are local bodies composed of non-police members empowered to review complaints, examine evidence, and make recommendations on discipline. When properly funded and authorized, CRBs can provide meaningful checks on police power. To be effective, CRBs must have subpoena power, independent investigative authority, unrestricted access to police records, public reporting requirements, institutional independence from police departments and mayors. Too many CRBs are symbolic, lacking teeth, or denied access. Reform efforts must push for structural upgrades, not cosmetic additions. Offices of Inspector General, OIG. In larger cities or state agencies, offices of Inspector General often serve as the internal watchdog for public institutions. OIGs must be granted jurisdiction to investigate police misconduct, authority to audit disciplinary processes, power to issue public findings and recommendations. Some of the most impactful police accountability investigations, from corruption in Baltimore's Gun Trace Task Force to cover-ups in Chicago's Laquan McDonald case, have come from such independent bodies. Role of the media and public databases. Investigative journalism. Journalists play a crucial role in exposing misconduct and prompting institutional reform. When public records are accessible, they can investigate patterns of abuse, profile repeat offenders, and hold both police and prosecutors accountable. Examples include the Washington Post's Fatal Police Shootings Database, ProPublica's release of NYPD misconduct records, the Invisible Institute's Citizens Police Data Project in Chicago. These efforts don't just inform, they empower communities, attorneys, and policymakers to act on truth. Crowdsourced and legal tech databases. In the absence of full official transparency, civil society has stepped in. Organizations like the Brady List Project, the Appeal, and National Registry of Exonerations maintain databases that catalog officer misconduct, wrongful convictions, and problematic law enforcement patterns. These tools provide defense attorneys and journalists with crucial information, even when state systems fall short. Policymakers should consider supporting these efforts or adopting their models into state-run platforms. Whistleblower protection and internal accountability. Transparency and accountability also depend on the courage and protection of those inside the system who speak out. Officers who report misconduct often at great personal and professional risk are essential to reform. Yet they are often met with retaliation, isolation, and administrative punishment. Enacting whistleblower protections. Departments must adopt strong anti-retaliation policies, backed by state laws that provide anonymous reporting mechanisms, legal protections against demotion or termination, independent review of complaints filed by whistleblowers, restitution and reemployment guarantees if retaliation is proven, changing the culture around reporting. Internal accountability also requires changing the perception of whistleblowing. Officers must see reporting misconduct not as betrayal, but as an act of integrity. Supervisors should be required to document how they handle complaints, and peer intervention should be part of academy and in-service training. Programs like active bystandership for law enforcement, ABLE, teach officers how to intervene when a colleague is at risk of misconduct. Such initiatives shift the culture from passive compliance to active accountability, building a national framework. Transparency and accountability cannot be left to local discretion alone. The federal government and national organizations must establish consistent frameworks that incentivize best practices and penalize noncompliance. Federal grant conditions. Congress and the Department of Justice can condition law enforcement grants on public access to misconduct records, Brady/Giglio compliance reporting, participation in national decertification databases, civilian oversight implementation, national decertification database. The lack of a national certification standard allows officers fired in one jurisdiction to be rehired in another. A nationwide mandatory decertification registry accessible to agencies and prosecutors would eliminate this problem. As of now, the National Decertification Index, NDI, tracks such information on a voluntary basis. Mandating participation and linking it to Brady compliance would strengthen both transparency and discipline. Conclusion. Transparency and accountability are not burdens, they are the architecture of trust. For law enforcement to be legitimate in the eyes of the public, the community must see not just the outcomes of police work, but the processes, people, and principles behind them. Improving these systems means committing to visibility, consistency, and integrity. It means recognizing that sunlight is not the enemy of law enforcement, it is its only durable shield. Truth cannot survive in darkness, and justice cannot be built on silence. As the next and final chapters in this section will explore, technology and procedural innovations can bolster this reform agenda, but they cannot replace it. Accountability begins with truth, and truth begins with visibility. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.